Welcome to today's program titled, Has the Dust Settled? Today's DEIB Landscape After the Students for Fair Admissions Decisions. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you so much, and welcome everyone. We are thrilled to be talking about what feels like an issue that has kind of changed certainly my practice in the last 4 months or so. I've long done work on diversity, equity, and inclusion matters, but certainly since the recent Supreme Court decision, we have had a significant uptick in the questions that are coming through. So the panelists here, Christy Kiley, who is my partner, and Gina Ferrari and myself, Annette Timon, we are all very, very deep into the questions that are coming up and that we're fielding since the Supreme Court decision came out. And in particular, I'm talking about what we're going to refer to as the fair admissions cases for purposes of our discussion in the education context. We started the thinking about what do we want to say because there has been so much activity. And as we titled the program, we were tossing back titles around, and the question was, has the dust settled? And in case anybody's wondering, it absolutely has not settled. We are in flux. There is so much back and forth. I don't know. I mean, I think employers are really caught between a rock and a hard place here, but we want to kind of break it down and answer some of the questions that we have been seeing. And on the next slide, you will see kind of where we're headed. So we're going to talk about very high level, the background of the decision, just for grounding purposes, and then see what some of the responses have been. We want to talk about the common questions that we have been receiving and potential responses that employers are undertaking with regard to their diversity, equity, inclusion practices. I also wanted to mention that Gina in particular does a lot of work in the ESG space and corporate governance space. So we wanted to bring her along to really give that kind of very, very broad perspective as well. So we're going to be focusing on specifically DE&I practices and strategies and audits and how you can, better position yourself. But we thought it would be really helpful to have Gina join this discussion because she is very familiar with the governance issues and the broader kind of ESG broader discussion that's out there. And so we want to bring that discussion point as well. So very high level, we'll talk about the background of the decision. By now, I'm sure everybody on this call knows the Students for Fair Admission cases were cases that allege discrimination against Asians. And these were in the education context. So the schools considered actively race and ethnicity as part of the candidate's application. And they did so because the Supreme Court had allowed them, through a series of prior cases, allowed the use of race, explicit use of race and gender in their specific programs. in that decision, which we'll find on the next slide, or the opening slide, refers to ultimately held that the policies failed to pass that strict scrutiny standard and violated Title VI and the Equal Protection Clause. It was determined by the Supreme Court to lack sufficient focus and measurable objectives that would have permitted the educations at issue to use race in particular, and they were basically using it in a negative manner. So the court, was a very, very long decision that really went through it, along with many dissents as well, which we are not going to go through that. If you really want some of that background, that we do have prior webinars that really went through that. But really, one of the last point that we on this particular slide, which some companies have then thought, like, how can we bring that? We'll talk about it further in other contexts. The court held that nothing in the opinion should be construed as prohibiting universities themselves from considering an applicant's discussion of how race may have impacted his or her life, but that express use by the admissions group in those cases was deemed to be violated the Equal Protection Clause in Title VI. So on the next slide, we'll see what the response was, right? So there was so much back and forth in the media, right? Pretty immediate, that really talked about, these are just some of the headlines that came out. And the question was then, okay, what does that mean in the employment context? And so here we have at the bottom of this, does the U.S. Supreme Court ruling on college admissions have implications for corporate DE&I initiatives? I mean, our phones are ringing off the hook on that specific question. And, we purposely made this pretty vague, right? Does it have implications? Sure, it does have implications. Did it directly say anything with regard to the employment context and how employers are actually describing affirmative action or implementing diversity, equity, and inclusion programs? And the answer to that is no. There was no direct change in the law at all, but it called for a lot of questions and issues that came up. So let's go ahead and go into the next slide, and we'll talk about the landscape post the Supreme Court decision. If you've been on at least our supplier diversity webinar, you may have seen a similar kind of review, but we think it's important to level the landscape here and talk about some of the specific issues that we have seen. So, for example, attacks on boards in particular, because of their diversity inclusion programs, we saw lawsuits on that front, and plaintiffs objecting because, from an investor perspective, saying the company has set hiring goals, has implemented other practices such as extending programs for supplier diversity and other programs that were violating the law, at least alleged, and as a result, that was having an impact on the potential investment dollar that the shareholders are using. Well, that case was dismissed by the court. The court had concluded, there wasn't a hint of legal merit, but that is one of the issues that we saw. We also saw pretty immediately after the Supreme Court decision on July 13th, and just by way of reminder, this decision, the Supreme Court decision, was June 29th. So within a couple of weeks, we saw 13 attorneys general sending letters to Fortune 100 companies, CEOs specifically, reminding them of their legal obligation not to discriminate. And, a few days after that, we saw a group of another 20 attorneys generals basically saying, hey, you should continue to move forward with your efforts, reassuring them that the information was lawful. And not long after that, we saw at least one Congress person, Maxine Waters, from the House Financial Services Committee, who issued a letter to those same 100 CEOs, urging them to move forward with their programs despite what she referred to as Republican intimidation in that context. We also saw attacks against law firms, right? So not only were there lawsuits, which many of you have been tracking closely to see law firms and how they might handle it with regard to their fellowship programs in particular, and how those were shaped out and how those were finessed. But also one interesting thing that we saw was Senator Tom Cotton sending letter to heads of many law firms, not only reminding them or sort of challenging them on their own DE&I programs, but what I thought was quite interesting was cautioning them about how they were giving advice to clients about corporate DE&I programs. So that really said a lot about how that position, or that letter anyway, came across. But those lawsuits, we did see some changes. There is a third, I think, right now, and there, the allegation is, well, if you are using race in particular, or gender, or any other protected category, that in and of itself is unlawful. That has been the allegation. We have seen a lot of public statements, and we'll talk a little bit more on the next slide about that in just a moment. But you have seen commissioners coming out in a very public way, some in certain kind of news outlets, others in various presentations, providing information, kind of fine-tuning what did the Supreme Court decision actually mean and what it didn't. And we have certainly seen a lot more, certainly a rise of what we're referring to as reverse discrimination litigation, and they are often using, so just to be clear, what we haven't seen, at least I'm tracking pretty closely, we're tracking pretty closely, and we haven't seen a lot of programs or lawsuits challenging a specific DE&I program, right? So this particular initiative is itself unlawful. Rather, it's a wholesale attack on the entire program, right? Person gets doesn't get a position or was part of a reduction in force, and they are saying, okay, I was discriminated against because the company has this overall goal to increase the representation of minorities, or increase the representation of women in the workforce, and here's all the statements that have happened, and here's all the programs that have happened, and all of that is evidence of how I have been treated in my workplace. They're trying to, get rid of me, or they didn't give me the job, or I didn't get the promotion. That's the flavor, as opposed to a specific attack on a particular program, at least so far. Then we move into supplier diversity programs, right? And as you know, we've got Section 1981. You cannot have a case, certainly under 1981 on the basis of race. But what's also interesting is we saw a real uptick in, or have seen an uptick in, the supplier diversity programs. And it has tended to be something that's not, it's not as grounded in the employment space, but because of the decision, there has been a lot more activity there. And we have seen employers really saying, okay, this is part of one of our pillars on our goal to ensure that we have a diverse opinions with regard to our customer base, but also our products or the services that we're providing. And so we are having, they have traditionally had a supplier diversity program, or many have, and that is also subject to attack. And then finally, just some challenges, which I believe Christy's going to talk about a little bit more, about private employer training programs. I will say that there is a decision that we have been tracking for quite some time. I don't, at least as of today, I hadn't seen anything that it had been that had come out and been final. That's the Florida case that specifically addressed what could and couldn't be said under their state requirements that would have impacted certain organizations, including schools in particular. And so that has been making its way. The 11th Circuit heard oral argument on August 24th on that particular on that particular case. So on the next slide, we're going to dive in a little bit more on the diversity fellowships in law firms in particular. Those lawsuits were brought by Ed Bloom, who is the kind of American Alliance of Equal Rights. That is the group that also brought the Supreme Court decisions in the education context. Two of the firms that, they were the first two that came out, that had been challenged on their essentially 1L diversity fellowship program, and two of the law firms ended up revising their statements and who their eligibility standards and how that would be positioned. So rather than relying expressly on race or gender or any other protected characteristic, there is now more of a focus on the way in which the potential applicant has demonstrated a commitment to diversity and inclusion efforts, right? So you can certainly be an ally or demonstrate some other ways that you have, championed DE&I efforts as part of those programs. There has been a third law firm that has been sued. That firm has, responded directly and pretty widely reported that, essentially saying, hey, just because we are referring to disadvantaged or historically underrepresented does not actually mean that means, race or gender. The other side talks about the public arena. I already detailed that, so I won't go into that. But once you do get the slides, which you will have, you'll have that additional context there as well. On the next slide, we'll talk a little bit about the EEOC commissioner's statements as well. I think this is fascinating, and watching the way that they approach, I won't go into every one of the text here, but just, when you get the decks, you can see them. Certainly Commissioner Lucas has been the one who has been most kind of front and center about challenges and where employers may have potentially gone too far in certain programs, right? All three of them make clear that the decision, the education decision, doesn't translate necessarily into the employment decision, and that it doesn't alter federal employment law, and Title VII has always prohibited using race as a factor in employment decisions. That is true, and that has not changed, and I think most employers have policies and practices that align with that particular summary, but if or that approach. But if you go through and you're kind of tracking, it's interesting to see where some sort of divergent of ideas comes into play. So for example, Commissioner Lucas takes the position that really the term equity, or the approach on equity, as she sort of looks at, I think is if I'm reading her statements correctly, or at least as attributed to her, her statements correctly, is more around fairness, right? Title VII doesn't really permit kind of a fairness quotient in looking at things. Really what it's saying is, employers, you're not supposed to be, you have to make sure that you're not discriminating, and there might be programs or practices that you're implementing to address certain issues, and that's all, Supreme Court precedent. It's been there on the books for quite some time, and certainly looking at your own programs and trying to understand, why am I not at a level of representation that I would expect based on availability, right? So taking a hard look at the whys, right? That is one thing I think that it's so important. It's not just the what are you seeing in terms of workforce representation. It's the why behind it, and then how you address it really, really matters in this context. So the next slide, just a couple more points here that I think are really important to keep an eye on. The Muldrow versus City of St. Louis decision is one that we are tracking very closely. It is actually a case that's going before the Supreme Court that talks about whether or not Title VII requires something more. I mean, most practitioners, or many practitioners, have long believed that you have to have an adverse employment action, right? So we're talking about hires, promotions, terminations, and other kind of material action in the workplace. But the decision really was a transfer. that did not involve a change in pay or benefits, and it only had really minor changes in working conditions, and that's not disputed at all, right? So this case is going up to the Supreme Court to make a determination about whether or not you need to have a materially significant disadvantage as a result of the decision. And the reason why that is important in DE&I context, right, is that oftentimes there are programs or training or I don't know, like an ERG or some other program that really it's an opportunity perhaps, but it doesn't really translate into a promotion decision or a hiring decision. And so those are the kinds of things that potentially could get swept up depending on how the Supreme Court decision goes. So we're watching that closely to see what the implications might mean. And then a couple more just very quickly. Ultiva Services Corporation really challenged. It was the first case that actually quoted the fair admissions cases, and through that program, the Small Business Association was actually using a program that they were permitted to give subcontracts to social and economically disadvantaged groups or entities. However, they had a process that they were supposed to kind of take a closer evaluation, and instead what they did was basically if you were of a particular race or a particular group, you automatically qualified as being socially or economically disadvantaged in the program. And that is what the court there found unlawful. And then just very quickly, 1981 of the Civil Rights Act claim is another case that we've been tracking, the Fearless Fund Management case. This one really is a private contract case. It is a fund that provides grants and other opportunities to small businesses, but it's alleged to apply only to Black women in particular. And that program has been challenged. They initially got a positive ruling, and they ended up appealing it within days. It was reversed, and a temporary injunction has been approved on that. So with that, I'm going to turn it over to Gina, who's going to chat with us about SEC reporting considerations.
So to follow on with the challenges that Annette's been talking about, let's first talk about the Alliance for Fair Board Recruitment versus SEC case. In that case, there was a challenge to the SEC's authority to require NASDAQ-listed companies to make statements about and or explain why they do not have at least 2 members of their board of directors who are diverse. Diverse being defined as someone who identifies as female or an underrepresented minority or LGBTQ+. And that was a win for the SEC, at least recently. So in the last few days, the Fifth Circuit came down, rejected the largely conservative supported Alliance for Fair Board of Recruitment, claims that these reporting requirements were outside the SEC's authority to issue them. There is an en banc petition outstanding where they've requested for the full court to look at the decision that rejected the challenge to the SEC's authority. And we should really expect this to be brought up to the United States Supreme Court. So while we're waiting for that en banc petition and or it to go up to the United States Supreme Court, listed companies are still going to need to report the diversity makeup of their boards by year end. And so I think that's a nice segue into thinking about, we've just been talking this morning about the number of challenges that are being made to different diversity programs or requirements, reporting requirements or regulations. And in the same moment, we have just in the last few weeks, the Investor Advisory Committee of the SEC voting to change the human capital management disclosures to be much more specific. And specifically, to start putting in these human capital management disclosures demographic data that's sufficient to allow the investors to understand the company's DE&I efforts. So you all may recall that in 2020, the SEC came down with some human capital management disclosure requirements, and it was very vague, left it up to each of the public companies to decide what was material in their human capital management. We knew that the SEC was going to come back and look for more specificity, and they have, following the fair admissions decisions. So you have, on one hand, a series of challenges to your programs, and then you have regulators asking you to provide more specific data. And so when we go forward in talking in this webinar today, we're going to talk to you about how you strike that balance. What do you do when you have these competing demands on you? So with that, we'll move to Christy, and she'll talk about some common questions that our clients are getting in the wake of these decisions and these regulations.
Thanks, Gina. Now that Annette and Gina have described all these moving parts that are out there, socially, legally, culturally, what is it that have been sort of keeping clients up at night, really proving challenges for employers? So let's go into the next section here. And we'll go to the first substantive slide, and we'll dive into a little bit of what we've been seeing. The first thing to note is that, as Annette said, the law has not changed in this landscape, right? And so the question is not really, are my programs legal now? It's, are my programs legal? Because they either were before and still are, or they weren't and they still are not. Back in 2020, when we had the aftermath of George Floyd's tragic death and Black Lives Matter, a lot of companies came out with very aggressive DEI programs. And I remember having conversations with people at the time saying, I understand what you're trying to do and why you're trying to do it, but just remember Title VII is still here, right? We still have some limitations under Title VII. So that has been the case for a long time. It's a really, really fact-specific examination of all these DEI programs. And I know that always comes across as a bit of a lawyerly dodge to a question, but it's the truth. You know, the details matter so incredibly much. And the tie that can be made between any protected trait, race and gender tend to get the most discussion, but it can be religion, it can be disability, it could be sexual orientation, where there is a connection between those traits and an employment decision, there is the potential for risk. But the details matter and the nuances matter. And the closer the tie is, the higher the legal risk. So I was describing it to a client today as I feel like employers are balancing on a very sensitive teeter-totter, because you take a step in one direction to mitigate risk, and maybe you're sacrificing some of the efficacy of your programs. Whereas if you try to build up the efficacy, are you also adding legal risk? It's just this incredibly hard balancing act that employers are dealing with today. So let's go ahead and dive into some of the considerations that have been impacting these different questions and assessments on the next slide. And this goes also to some points that Annette was making. It's not just a legal issue here. Yes, the law matters, and what's permissible and not permissible under the law matters. But if the last few years have taught us anything, it's that there can be huge drivers out there in the media from stakeholders like boards and shareholders and employees and applicants for employment, advocacy groups like Ed Bloom and his organizations. This is not just a legal question anymore. So lots of things going on here. An example of sort of the tension that we're facing is in the next slide. This is a case brought by a gentleman who was employed by the Department of Corrections in Colorado. And he actually filed his first lawsuit back in 2022. And he was challenging the DEI training that he was put through from the Department of Corrections. He said, it's kind of interesting, his complaint was dismissed essentially because he didn't say what the actual training was, which is a pretty important detail if you want to bring a suit. But he alleged that the training was essentially contained racist materials, that it used sweeping negative generalizations about individuals who are white, that there were all of these sort of race-based problems in the training. And then he alleged that the content was so severe, it not only created a hostile work environment for him, which is what he was suing for, but it created a culture of suspicion and distrust throughout the Department of Corrections. And so that was the basis of the lawsuit. The court did dismiss the case because, again, he didn't provide the training or say what it actually was, and so he didn't withstand the pleading standards. He then refiled again in 2023 while the prior case was still on appeal. So he's really trying to go after it here. The 2023 case has been stayed until his appeal is considered. So the case is still live in the sense that there's opportunities for some more decisions. But it just kind of goes to show that employers, it's not even a rock and a hard place anymore. I feel like that would be a welcome position. It's like being on this tiny little tightrope between two huge hazards on each side, right? It's very hard. And so there is a peril, as Annette mentioned earlier, to trying to do the right thing and advance DEI. There is still going to be detractors on the other side who find a way to take issue with it and pursue legal claims. We still feel like DEI training is low risk overall. It's very hard to claim that it somehow violates employment rights under Title VII, especially if the content is thoughtful and vetted and reviewed by legal counsel. The Stop Woke Act that Annette mentioned in Florida is still enjoined as of today, so that is not in effect right now. So in general, DEI training is low risk, but possibilities exist out there in virtually any context. So let's go to the next slide. What are employers telling their workforces? What do you tell employees who ask, what's our company's position on this? Where do we stand? Are we canceling our plans because of these fair admissions cases? Are we getting more aggressive? It's a tricky issue. Messaging really does matter. Hopefully businesses have a communications plan in place right now, ideally with a partnership of legal and sort of PR communications teams, personnel. They need to be working together on these because again, there's that line between wanting to advocate for DEI on the one hand and wanting to make sure that you are navigating these very complicated contours of the law at the same time. Some companies did come out and make direct statements after the decisions from the Supreme Court, either internally, externally, or both. Some companies came out and said, we're going to remove the uncertainty. Here is where we stand. Typically a different tone, right, when you're dealing with your internal workforce than externally. Other companies didn't address it at all, right? We're just going to keep on keeping on. Our employees know where we stand and what our culture is, and we're just going to keep going forward. So there's a real variety to approaches out there, but it was something that I think virtually every company struggled with at some level in terms of how to message and whether to address these issues head on with your employees. Let's go ahead and go to the next page. And I've already touched on this. This was the reference to the teeter-totter that I mentioned. But it also incorporates that aspect of how it's legal and practical considerations, because it's not just a question of, is our program lawful? It's how is that program received? Is it supported by our workforce? Is it effective? Is it even doing anything, right? There's a lot of things that need to be considered here. And the risk tolerance of an organization is a big piece of that. Some organizations want to be the front runners in the DEI space. They want to be the ones out there pushing the envelope and really aggressively advocating for change. And that's great. Their risk profile is going to look very different from someone else who wants to advance DEI and do the right thing, but doesn't want to have their head stuck out and doesn't want to be the test case for some of these things. So the risk profile really matters in terms of where organizations land in this. But doing nothing can be a problem, as can doing too much. So it's a challenge of finding that middle part of the road. So one more slide, and then we're going to turn it back to Gina to talk about some more of these corporate governance issues. But again, every business really is unique here. And as you struggle with this within your own organizations, one important thing is to make sure you're considering the views of all those stakeholders. More people are invested in DEI one way or another than you might think. It's not just, the offices of diversity and inclusion or your EEO officer. It's also things like talent development, it's talent acquisition, it's recruiters and hiring, it's executive compensation and total rewards and, benefits programs and comp programs that may have some tie to an aspect of a DEI program. All of those points of view really need to be taken into account and considered. And then, of course, it's going to matter too, the size of the business, the industry. Some are definitely getting more attention than others, and you tend to know where you fall within that if you're in-house counsel or staff in an organization. But we're going to talk in more depth in this presentation about doing a DEI audit. And that is something we highly, highly recommend. This has become a huge part of our practice. It's sort of fascinating to me that something we hardly did at all a couple of years ago is now this sort of majority of what we're spending our time on. But DEI audits are really important to understand where your business falls in all of these areas. The one thing we did want to make sure to note, and Annette and Gina and I were all talking about this prior to the presentation, is we are not seeing employers backing off from DEI. We are not seeing huge changes and eliminations of positions and reductions in budgets and walkbacks of programs. Is some of that occurring out there? Sure, some of it probably is, but the groundswell that we're seeing is still a lot of support for DEI. And in general, there's certainly no reason that you need to walk away from your organization's commitment to it as a principle. So with that, Gina, I'll turn it back to you.
So on the next slide, we wanted to start talking to you about what each of your peers are seeing. So across industries, we're seeing an increase in advisory votes, demands for advisory votes, and shareholder proposals. So shareholder proposals and the rise of shareholder proposals in the DE&I space, that's not new. But the makeup and the requests that we're seeing since the fair admissions cases are a little bit different. We're definitely still seeing, and to Christy's point, shareholder proposals and requests that relate to ensuring that you're actually meeting your goals as an organization and actually achieving more, right? People are not, even the activist groups, NGOs, and the folks that are making shareholder proposals still want to see a majority of, or a fair amount of the organizations hit their goals and metrics and improve on them with respect to executive compensation. Some of these shareholder proposal demands are asking for the audits that we're going to talk about later in this program. And the audits cover a fair number of different areas. So what is your DEI program? What are your policies? What do they state? Again, are you meeting those metrics and those goals that in the statements that you have put into the public, whether it's in public filings or your ESG or impact or sustainability report, or simply in press releases? And, you know, and Annette and I were talking about this as the program began. The last few webinars we've had, and I'd say the last year, we predicted that there would be a continued push for more civil rights audits to ensure that companies are really taking stock of any issues surrounding civil rights. And now we're seeing a shift. I wouldn't say equally, but there is a good number of shareholder proposals that are asking companies to return to a merits-based analysis when we're looking at different programs. So again, this tension that we've been talking about throughout this webinar, how do you strike this balance? What's the teeter-totter that you're on? We see requests on both ends of the spectrum, really, in these shareholder proposals that we've been tracking. So where there's requests for racial equity or pay equity audits, then we're seeing other shareholder proposals that are asking companies to simply prohibit political speech. They say it's not good for the profits of the company. They very specifically, there is a large number that is encouraging boards to go back and improve disclosures, revise their reports, and assess litigation risk. And so we're going to talk later in this program about some of the language that goes into the disclosures and the revised reports that is an improved set of language considering the fair admissions decisions. We're also seeing organizations ask for assurances regarding their DEI programs, all ESG. So it's happening in the environmental context, but it's definitely happening in the social context. And what do those assurances look like? Well, many of them are through third-party consultants or attorneys. There are letters that sit on top of ESG reports or disclosures that are very detailed and basically say things like, we confirm that we're responsible for determining this information, and then lists a lot of very specific information, including data on DEI metrics in some instances, that we have a high level of assurance that the information is correct. We make the following representations to you, and if there are any misstatements, we believe that they're immaterial. These are big asks and important and potentially high-risk statements that are being put out by organizations, because all of those statements are likely to potentially lead to litigation on misreps or omissions. But the industry is demanding it, and it's not just demanding, the demands aren't just coming from the organization or from NGOs or shareholders. They're coming from vendors and individuals within your supply chain so that they can attempt to accurately state their DE&I metrics and achievements. And we've seen, Annette and I have had long discussions about assurances regarding up and down your supply chain in each direction, and how do you make those assurances? That is a huge undertaking, and it's still up for discussion on the best practices in making those assurances. So while we're talking about what your peers are doing in the industry, we can see on the very next slide a portion of CIFAR's human capital management report that it's been putting out since the 2020 changes coming out of the SEC. So in 2021 and 2022, CIFAR looked at several hundred companies within 10 industries and looked at their public disclosures to see what they were deciding was material. If you'll remember earlier in the presentation, I said, as of right now, the SEC regulations require a company to decide what's material with respect to their human capital management. And on this slide, what we're seeing is a number of DEI issues are really across industry already being reported in public disclosure. So you can see that on the diversity and inclusion line, the pay equity line, and frankly, a number of the other categories cross over with your programs and your policies on DE&I. But almost universally, we get, other than in transportation, we're in the 90s to 100% last year before these decisions came down. Now, on the next slide, we can show you what we've gathered to date for 2023 10K disclosures in a few of the industries. When we're looking at the slide, what you see is there's actually an increase in looking at very specific metrics and actually disclosing them in public filings with not only metrics that have already been achieved, but what are the future goals and initiatives, and what are the programs that are focused on making sure diverse employees are retained, recruited, and part of the makeup within the organization in greater numbers. What we don't know from this data is whether or not some of this aggregated data happened before the fair admissions decision. So the 10Ks come out based on each company's fiscal year. And this is gathered from all of 2023. But again, many companies' fiscal year ends at Q2, and then they report between 45 and 60 days after that. And that's after the fair admissions decisions. So I think it's fair to say that your peers are continuing to have programs, policies, and goals that, again, we don't see the DE&I programs going away. So with all of this in mind, again, competing interests, knowing what your peers are doing, what's the practical advice that we can provide for you based on this increased scrutiny? And I'm going to hand it back off to Christy to talk about that. And she's going to start in 2 slides and really digging into the audits we've been talking about.
And the good news is there absolutely are things that businesses can be doing right now to get a better handle on where they stand with regard to priorities and risk, and also to potentially improve or mitigate in areas it chooses to do so. So let's go to the next slide, and we're going to dive more into that concept of a DEI audit that I mentioned a few minutes ago. DEI audits are fantastic ideas, and there are two primary reasons for that. One is so that the company can figure out exactly what it's doing in the DEI space, which might sound obvious, but it has been really illuminating to see since these decisions came out how much can be out there dispersed in the organization, and the centralized decision makers or headquarters or corporate office don't necessarily know about all of them, and certainly haven't been involved with formulating some of them. So just finding out what your organization is doing and where it stands is one reason to do this. And then the second is to get a handle on whether and where you may have exposure, either as a practical matter in the sense that you could be targeted and have negative publicity and the distraction of these allegations, or legally in the sense of actual legal risk. The only way to find that out is to look at these programs in great detail. And things really have changed over the last few years. Stuff that you may have been doing in 2020 may or may not be what your organization wants to continue doing now. So it's a really, really great tool to get at both of those things. It also gives you a chance to go ahead and hit the reset button if you want to, or to just update and make changes. If you like the way everything is, it gives you a chance to re-message it and put it out there and sort of reaffirm the company's commitment to what it's doing. So it's just a great opportunity to bring the issue of DEI front and center and really make sure you're handling it in a strategic way. On the next slide, we have an overview of what the process typically is in doing a DEI audit. And there's no rocket science formula here. It's pretty straightforward. You start off by identifying the folks that you want to be working with. And you want to make sure, again, that you're not just including legal and HR, but you're including other folks who may be invested in these DEI programs. And then we strongly recommend that it be done under privilege, right? So you can undertake the type of detailed, careful analysis that you need to be able to do to get a sense of your organization. And then you move on to what I described, just trying to identify what all your initiatives are. What are your programs? What are your policies? What are your practices? What's out there in writing? What do you have on your websites? What do you have in your proxy statement and your shareholder statements and things like that? I'm looking at a lot more of those statements in the last year than I think I ever have in my career. And then once you get a sense of the universe of things that you're looking at, oftentimes you need to prioritize and set a plan for how to deal with those, because there may be so many different components that it's not realistic to tackle them all at once. And we have a range of audits that we see clients requesting. Sometimes it really is just, this is our signature program. We want you to take a look and let us know how it stands. Other times it's the more comprehensive A to Z. We want to look at everything. Tell us if certain terms should be phased out, given that language evolves in this area very quickly. Tell us if we should tweak or change certain components. So the scope is really flexible and just dependent on where your organization is in its DEI journey. You often talk to folks who are involved. What employees perceive as the policies is often tellingly different than what the policies themselves say. And that's very important to get at. So talking to folks is another way to do that. And after all of this various information gathering, you do the risk assessment and you decide, again, whether change is required, if so, where, if so, how are you going to message that? How are you going to communicate it? How are you going to balance out and make sure you're not perceived as, stepping back from DEI, for instance, if you think something needs a little bit of adjustment. So that's the overall process. We are seeing trends and the challenges that companies face, which we go into a little bit on the next slide. There we go. And one of the biggest is just this practical hurdle I mentioned of finding all of these DEI initiatives, because sometimes DEI gets its tentacles out there in the organization, and individual units or supervisors or departments may have their own initiatives. And that's fantastic. That's great if they're doing that, but the company needs to be aware and needs to know what those are. So just making sure that you've done a comprehensive survey can be one of the initial challenges. The other thing is you need to make sure, just like with everything, right, that you've got buy-in from the top and that you have commitment to really doing this the right way. Because if you're just going to do it on the surface, it's not a worthwhile exercise. You have to be willing to invest, the time and resources, and both in terms of budget and in terms of buy-in. And then fleshing out the scope. Typically, we're just looking at current policies, but sometimes there are those in the works, that are planned for the future, and it's absolutely appropriate to be looking at those right now too, with a lens towards the legal landscape. So I think that takes us through the audits. Annette, do you want to go ahead and bring us into, oh, actually, we have one more slide, sorry, and then I'm going to turn it back to Annette. Let's talk a little bit more about training. So I talked about training and the Stop Woke Act, how that's enjoined, how this lawsuit over training really didn't go anywhere. In general, DEI training seems to be a fairly low risk activity. I personally am a huge proponent of training. And I know that's not a view shared by everyone. Some people think that training is not particularly effective as a tool, and there are certainly reasons individuals might think that. I think training matters and can be very effective when it's done well, because it's how your company tells employees what you think about something. And you do it in a more meaningful way than just sending out a policy by email or putting it on a board and saying, read this, this is what we're doing, right? When you do a training and when you do a good training, you are really talking and engaging with your employees, with your management, with your HR, with the people speaking for your organization. And you can speak very genuinely and sincerely to these difficult issues. And you get really genuine and sincere feedback in return from the folks who attend. So it can be a really effective tool if you're not currently doing it as part of your response to these DEI issues. It's something to certainly think about. A myriad of ways and topics and different things in terms of how it can be done. But as a general rule, it is one option you have to respond to these issues. Okay, so Annette, now I will turn it back to you for some more practical pointers here. I think you're muted.
Sorry, in my attempt to not have background noise, I forgot to unmute. All right, so we'll move quickly here because I know we're getting to the top of the hour here, and I want to make sure that we hit on some of these issues. And we're trying to fold in some of the questions that are coming through the chat through this. So, we're talking about the legal risk of programs, and through that audit and through that review, right, taking a closer look at where you're at as an organization is really important. Okay, and so those programs that are in close proximity, just generally speaking, what you'll notice in our presentation is that we didn't go through and say these are the high risk areas and here's the low risk areas, because it is so nuanced. That is the reality. I can take almost any program that you can think of, even the training that most of us would generally say, okay, pretty low risk, and this is important to have, and then you can ratchet that up and make it potentially one that does get to a kind of a higher risk profile. So that does require more nuance and discussion, and that's actually what we do when we're doing these audits, right? So trying to understand the program specifically. How close is that program, first of all, to the specific employment action that you're talking about? Who's making the decisions? What do they know about the race and gender of the individual or any other protected category? The more, the closer that decision is to the ultimate employment decision, the higher the risk. The closer, the more that decision relies on race or gender or any other protected category, again, the higher the risk, and who has that information is really important. So there are strategies that we look at or advise on to say, okay, let's take that program. Can you separate the decision making from, so the people in the hiring chain or in the specific decisional process, there's kind of a dual approach so that you're not sharing race and gender information. There's lots of ways to kind of tone down or eliminate, not eliminate, I don't want to say eliminate, mitigate some of the risk. And that's really what we're focused on doing. The other thing is talking about program effectiveness, right? It is really important to understand whether the program that you have in place or that you've implemented is actually having the desired impact on what it is that you're trying to achieve. So it is not the case that every company needs to have a diverse slate program for all positions top to bottom of the organization. If you are not getting the requisite percentages of individuals applying to your jobs, then you can have diverse slate programs all day long, but it's not going to the specific issue that you're not getting proportional applicant flow of individuals that are qualified for the specific jobs that you're recruiting for, right? So it's really important to narrowly tailor, and having a company-wide program sometimes it is appropriate and sometimes it's not, right? You might have to have a targeted program for your sales organization that is very different from what you do in IT or finance or in any other group, right? So thinking through those issues is important. Certainly from our perspective, the more tailored the program is, generally speaking, the less legal risk, especially if it aligns to data, because that data may be revealing areas where you actually have areas to address. We're going to keep going and talk about language quickly. The next slide talks about, talking about how you're positioning information. If you're talking about quote unquote gaps in your representation, that is going to potentially, cause some alarm bells to go off and potentially, call upon or kind of invite potential litigation. And certainly avoiding language that indicates that only certain groups are going to be getting a benefit is really important. I know that there are, it's been challenged, right? For many years, I was starting to hear things like we're going to engage in outcomes-based decision-making, and that's pretty challenging and pretty tough under Title VII. So thinking about it, especially when you think about there's an important letter in the DEIB category, and the belonging piece, the B, is important so that everybody feels, has a sense of belonging within an organization, and all viewpoints are heard and understood. Thinking about how you share communications, whether it's external versus internal, are you sharing and how you're sharing with your senior leaders versus all employees or all hands on deck sort of approach, and you want to ensure that you've got the practical guidance is aligning with your policies themselves. On the next slide, we'll talk about, focusing communications on the journey or the progress an organization has made. Typically, it's better to focus on, again, sectors or levels within the organization, business units, rather than across the board hitting every particular group, and being mindful about how information is going to be received by all audience. Again, going back to that belonging aspect. The next slide, we'll talk about data and analytics. I mean, it's really important, right? There are some questions about goals that come up, and these kinds of things, whether they're aspirational, targeted goals, it's really important. And you have to assess, we've talked a lot about risk, right? There are, even within risk, there are varying stages of risk, right? There's reputational risks that there might be. And then when we talk about risk, some clients, what is it that you are most concerned with? Do you not want to receive a lawsuit at all? Do you want to ultimately, prevail kind of on a motion for summary judgment, or are you prepared to take something all the way to trial and perhaps win there? Because those are varying levels of risk, and how you position yourself, how you think about the organization is really important. So you might ultimately prevail at the end of the day if push came to shove and you went to trial because you were able to demonstrate that even if you had an aspirational goal, how you achieved that goal is very lawful, right? On the other hand, though, it takes some work to be able to demonstrate that all the activities that you did not actually take race and gender into account, except for the very narrow circumstance, which we're not going to go into here, is that manifest imbalance standard. Data helps you support your overall policies, practices, and initiatives and strategies as you move forward. And then the last section that I'll touch on is the other, pay attention to what's going on in the news. These issues, you do not have to be in HR or in labor and employment to understand that these issues are all over the news. You're just reading and paying close attention. There are groups that are specifically targeting goals and strategies, and they're pretty open about what those goals and strategies are. And then with that, I'm going to turn it over to Gina, who's going to start us off with that CLE that everybody's waiting for and wrap us up. Next slide.
The CLE for today is SS4254. Again, that's S as in Sam, S as in Sam, 4254. So some high-level takeaways for you to really make sure that you're reducing your risk and increasing your opportunity. The best place to start is define specific success for your organization. that can be done with a purpose statement, a mission statement, and looking at all of the charters for not just your board, but your special committees. Once you've set the groundwork for that, you should then go collect the data and figure out where are you right now? What is the state of your policies, your statements, your reports, and also anything that's public facing and anything that's internal facing, and modify that language where it's needed, just as Annette and Christy talked about. And maybe it doesn't need to be modified, but again, you're going to take stock of what you already have and see where you need to add, massage, or take back some language, but not your policies. And one of the good ways to then move forward is to decide who is going to be responsible for each of your DEIB programs. And maybe you're going to expand that to adding it to the charter for the compensation committee and changing how you report back up to the board. So be really thoughtful about who should be responsible, and does that need to expand? There is a lot of best practices out there that are considering that you should maybe add DEI to the compensation committee. But remember, you want to set in stone then reporting metrics and proper oversight. Annette,
Sure.
what would you say about establishing these targets and meeting them?
Yeah, I mean, really taking a look at those targets and meeting them. The how, right? We talked about the what, but how you go about achieving those targets are really going to be front and center in any lawsuit. That's really where the risk is. I used to say the goal in and of itself shouldn't create legal risk. It's how you get there. I would say since the decision, risk, if you're concerned about it meaning you get flagged for a complaint, that is certainly an issue that could be out there. I still think that you can move in that direction. However, understanding that there are risks associated with that. Certainly, we've talked about the other pieces, the enhancing the programs. I guess our big takeaway here is we do encourage you to continue to move forward with your diversity and inclusion strategies. This is not the time to necessarily back away. It is a time to reflect, review, potentially finesse, certainly modify certain language that you might need to finesse, but by all means move forward. At the end of the day, we want to make sure we have inclusive workforces for everybody. And if folks want to progress in your organization, you want to make sure they have opportunities to do so. So with that, we thank you so much for participating in this session. We're happy to discuss further. Our contact information is available to you, and we hope that you found this information helpful to you in your organizations as you move this really important considerations, and it's tricky these days. So hang in there. There is a lot of support that's available to you, and we encourage you to keep moving forward.
Thanks, everybody.